Kippa is here with his client. We're here for a sentencing today. There is a pre-sentence investigation report that's been submitted. Attorney Kippa, have you received that and reviewed it with your client?
Yes, Your Honor.
For count 1, that's an attempt offense, so I believe the penalty is half what's stated there for the maximum penalty, correct?
Judge, correct, and that was the one, I guess, inaccuracy that I identified in the PSI.
Okay. Attorney Kippa, any comment on it?
It's consistent with what I wrote on the plea questionnaire, so I think you're right. Yeah.
Okay. Excellent. And then Attorney Kippa, any other corrections to suggest?
Judge, there's a clarification. I think it's more of a typo than anything, but I think it's important and worth noting. On page 22 of the pre-sentence investigation, under the substance usage history, agent comments, third paragraph there, maybe 2/3 the way down. It says Mr. Paulus does not feel he currently has or ever had an issue with alcohol or drugs and is currently not interested in participating in treatment. It's contradicted by what she says later on page 27, second paragraph. Mr. Paulus expressed benefiting from participating in treatment for both alcohol and drugs. So he certainly acknowledges issues with substance abuse and is open and receptive to treatment. So I think our second comment is more consistent with his position.
Okay.
That's
Thank
it,
you. And then you submitted the report from Dr. Miller, correct?
I did submit it. There's a typo there. It's called the psychosexual. It's really not. It's a psychological examination. I don't know that the distinction, to a professional, the distinction is great, but the court probably got that it's more of a generalized psychological evaluation.
Okay. You mean just with the title that was given the document at the clerk reports?
Yeah, my
Okay.
staff, I think, mistitled it.
Okay. And you're offering that for sentencing, correct?
Please.
Any objection from the state?
No objection, Judge.
Okay. Then is anybody testifying for victim impact?
Judge, I would note for the record that there are a number of people present on behalf of the crime victims, and just to start, here I have provided the court here and the defense counsel with a courtesy copy of the amended victim identification key. It's document 24. Judge, I'm going to be referencing the parties based upon these pseudonyms listed in the victim identification key, just for the sake of their privacy. So, here with that being said, the parents of victim number 2 here are present, and the parents of victim number 3 here are present, and here the mother has asked, mother of victim number 3 has told me that she wants to exercise her crime victim rights and give an oral victim impact statement here in court. Judge, I also have courtesy copies of the victim impact statements, written victim impact statements from here the mother of victim number 4 and the mother of victim number 3, who is also going to be speaking here in court. May I approach?
Yes. Thank you. Okay, these were previously submitted to the court. So they have already been reviewed by the court.
Thank you, Judge. Here, with that being said, here's at the court's preference to have the crime victims speak first.
Yes, let's do that first, yes.
Judge, and before we do this, so I had spoken here just with media members and asked that they don't capture your the victim's mother, her physical appearance. She has no problem if they record her voice, but just for her privacy.
Okay. Then I'll issue an order accordingly for anybody who may be here recording the proceeding from the media. that you can play the audio, but not the visual appearance of the victims on the case. Okay, move the microphone closer.
This might take me a minute.
What are your initials, first of all?
EKB.
Okay, thank you.
For victim number 3.
Okay, thank you.
Your Honor, hi, my name is Emily Bosch, mother of the third victim, Peyton Bosch. I am writing this today so everyone is aware of the huge impact Mauricio Paulus has had on my family, especially my daughter Peyton. We planned a little family getaway that weekend. 1 minute, please.
Take your time.
We planned a little family getaway that weekend in January 2024 to get away from town, relax, and have a good family time. Well, it was anything but that. It was actually quite the opposite. It has been a little over a year since that day, and we still struggle emotionally, physically, and mentally. The way she screamed for help when it happened replays in my mind constantly. My son and daughter passed him in the hallway. He is the one who decided to turn around and follow them. Thank gosh their destination was to knock on our hotel room door where we were staying and where I was, because I was right there. I did chase him as I seen the staircase door closing, but he was already out of my sight. But to do what you did and tell my daughter he tells me you thought this was just hilarious. Why did you think any of this was okay? And a question I have is, what is next for this man to act upon after his short 3.5-year sentencing, if that's what he gets? Because he was just seeing what he could get away with. If this happened to your child, please ask yourself, would I be okay with this person going away for 3.5 years? Mauricio, you mentally messed up our innocent daughter over something you thought was funny. Peyton is going through 2 sexual assault cases at once right now, so it is very hard for her to concentrate on anything. My son Remington, who is Peyton's younger brother, was with her that night when she was sexually assaulted, so it also has impacted him greatly as he couldn't do anything to help. He felt helpless. Peyton and Remington have both missed days of school because of it replaying back in their minds. Peyton is extremely afraid of men and boys now. She always has to be with me anywhere we go. She wakes up in the middle of the night sweating because of the playbacks in her head, crying, and refuses to be alone even at home. She sees her counselor weekly and sees someone with a sexual assault center in Marinette, Lacey, who we are very thankful for. They both help her very much. If she feels like she needs to get out of class for a while, she goes and visits her school counselor for as long as she needs. Peyton and I also talk about her future and how to try to ease that trauma so she doesn't carry on with it when she's an adult and needs to go off to college on her own, wants to meet someone, get married, have children, etc. These are all things that she will now struggle with because of what happened, and that's a very big deal. She won't even use a public restroom alone anymore. Not only did Mauricio Paulus do this once, not twice, but 3 times on 2 separate occasions a week apart, where he had time to think about what he had done and then come back and act upon it again. That's not someone caring about what they're doing. I am asking he get at least 4 years per child and a solid 10 years out Another important note I wanted to say was I was told by 2 different men that sat with him in jail that he laughs and brags about what he did. 2 people found me on social media, didn't even know it was my daughter, told me about it. My daughter will forever suffer. She will learn to cope, but she will forever have it with her the rest of her life. At 13 years old, that is not fair. It isn't fair for any child. I also now have a huge fear of letting my children out of my sight even for a moment. He chose to go there that day and do that to young children, and then chose to go back a week later. Mauricio, during your first court hearing, your apology at the end cut me. You were crying and saying sorry. Sorry doesn't work. You don't get to apologize and you do not get to cry. You made that choice for yourself. Our girls did not have a choice. Our girls, like I said before, now have to carry this with them forever. These are young, innocent girls whose lives you've traumatized. No man, let alone anyone, should ever be touching children. To drive to a family water park and do it 3 times is crazy. So I'm asking for 4 years per child. And before I'm done speaking, I want to also make it a point to say that because of all this, I had to be here to speak on behalf of my daughter, to be her voice. While I miss her very first track meet that was out of town today. So instead of her having someone cheer her on in the stands, I am standing here instead, rooting for her in court while she's alone performing today. And that breaks my heart as well. Your Honor, thank you for giving me the opportunity for my voice to be heard, as I feel we haven't had much say in the legal process. It really is extremely important to me to have a say for my daughter and the other 2 victims who have to now suffer, as I feel 4 years in is not enough for sexually assaulting these young girls, one being my daughter, and at a family water park. Thank you for your time, Your Honor.
Thank you. Was there anybody else, ADA Dorsey?
No, Judge.
Okay. Then we'll go to sentencing at this point. The state can go first.
Judge, thank you. Here, I think those comments right there really speak to the gravity of what this case is and the impact that Mr. Powell's behavior has on not just the individual crime victims, but on their family members, on the community as a whole, right? This court has a number of people present in it. People here on behalf of the victims, people here on behalf of Mr. Powell, and members of the media here documenting this here for the public. And that's because this is an important case. And this case was, Mr. Powell was charged with 4 very serious felony offenses. He now stands convicted of 2 offenses, one being the attempted first-degree sexual assault of a child. He's exposed to 30 years of imprisonment here in the Wisconsin State Prison System. He's also convicted of count number 3, second-degree sexual assault of a child. He's exposed to here a maximum term of imprisonment of up to 40 years. Mr. Powell, being an 18-year-old man with no prior convictions, is going to have to carry these convictions with him for the rest of his life. He's going to be a registered sex offender mandated by law. He's going to have lifetime GPS, and that's a collateral consequence for his behavior. We, during this process, me and Mr. Kippa, had extensive negotiations, and we ultimately got to a point where the parties are able now to jointly recommend what we feel to be a substantial prison term for Mr. Powell, given his age and no priors, but that adequately factors in kind of all the facts and circumstances that I'm planning on discussing. But specifically, our recommendation, the parties are jointly recommending a period of imprisonment of 11.5 years, bifurcated as follows: 42 months of initial confinement, 98 months of extended supervision. The parties are asking that this court incorporate all of the conditions of supervision set forth on page 29 of the PSI, notably no contact, including personal contact, written contact, electronic communication, here with all the crime victims that are identified in the amended victim identification key. That also includes their family members, their places of residence, schools, places of employment. State's asking that there also be a GPS exclusion zone, given that GPS monitoring bracelet that he'll be subject to for the rest of his life. Here around, here are all the crime victims' residences, here their schools and their places of employment. State's also asking for no unsupervised contact with any minors, no contact with the Tundra Lodge premises, no contact with any of their employees. Compliance with Wisconsin's sex offender registry program. Again, that is a mandatory lifetime penalty that's associated with these cases. As an 18-year-old man, that will follow him for the rest of his life. Parties are also asking for a compass evaluation and follow-through. Here, an AODA assessment and follow-through, mental health evaluation and follow-through, condition of absolute sobriety, no contact with any known drug users or dealers, random drug testing, restitution has here been partially prepaid, and that was a factor here in these negotiations. And it's my understanding that there are going to be here potentially future requests. Here I know the family for victim number 3 here has a $60 restitution claim. Still awaiting feedback on victim 1 and victim 4. But state would be asking for a 60-day hold open period on that issue.
But the request here right now is victim 3, $60?
Correct.
Okay.
Judge, with these types of sentencings, I always analyze things from the public's perspective, the public interest. We are, as prosecutors, officers of this community, tasked with enforcing Wisconsin's criminal laws. I've had the opportunity to consult with other prosecutors here in our office on this case. I've worked diligently with Mr. Kippa on this case. There's been a collective here, I guess, determination from our office that this recommendation is appropriate, that it reflects Mr. Powlis's his age and lack of record, which here courts routinely factor, balanced against the very serious nature of these crimes, his conduct, his egregious conduct, and the need to protect the public from Mr. Powlis's potential recidivism. Here, this recommendation promotes both general deterrence. It puts the community on notice. It puts young men, young kids, let's say seniors in high school, freshmen in college age boys, here, if you do this, you're going to prison. I think that's important. Even if you don't have a blemish on your record, if you do this and you're that age, you're going to prison. That message needs to be sent in this community, and I believe this sentence accomplishes that. We also feel that this recommendation will afford Mr. Paulus the opportunity to correct himself. Now, me and counsel have a joint recommendation, but we probably disagree as to what the root cause of this is. You know, in reviewing Dr. Miller's psychosexual evaluation, I noted, you know, some comments, and look, I don't read Dr. Miller's report here as a defense-oriented report. I think it's fair and balanced in some sense, right? But here I don't think this is a case of Mr. Paulus, who was a young kid who was spending his money that was conveyed to him based upon his age and graduation as being a member of the tribe. I mean, it was a substantial sum of money here for drugs, and he got bored and wanted to play a prank on some kids. I don't think that's what this was, you know. I think it's more accurately reflected in page 11 of Dr. Miller's report of specifically sub 5 on the index offenses, 5.3. He says, Mr. Paulus says he was excited by doing something illegal and seeing the shock value in the victims. Hearing that the children were safer targets for him. So I just read this in preparation for this sentencing, and here after we had come to a joint recommendation. But that tells you what the mentality is with the offender. He doesn't care about other people. He takes advantage of the vulnerable. His sexual preferences and behaviors outlined in the PSI, and I won't here discuss them. Just out of politeness and respect here for the court, is such that he's a porn addict that wanted to go and realize his fantasies through action. And that's what he did. He went to a hotel. So all the documentation indicates that he had been to the Tundra Lodge in the past. In fact, he had had romantic encounters with his partners there at the Tundra Lodge. He knew the layout. He knew where to navigate. That's why he went there. He did what he did. And I'm not going to describe the conduct here again out of respect for the crime victims. I will just make note, though, that the assault of victims 1 and 2 is described here in the criminal complaint, pages 2 and 3, here in detail by Officer Eck, and I'd ask that the court take notice of that conduct. Here again, I'm not going to get into the description of it because here...
Give me the citation again, I had a different document though.
Sure, it's the criminal complaint, document number 2, pages 2 and 3. I would direct the court's attention to the report of Officer Eck.
Okay, thank you.
He describes the assault of victim 1 and victim 2. Then on the assault of victim number 3, that's described on page 4 and 5 of the criminal complaint. Again, court filing number 2. That was, that includes Officer Dimity's report that outlines what happened. Here and then the assault of victim number 4, that is described here by Officer Brentison on page 6, starting at the end of page 6 onto page number 7. That conduct speaks for itself. That conduct is inherently aggravated. His conduct is made more aggravated by the fact of multiple victims, 4 victims. The ages of the victim, here is another aggravated factor. The amended victim identification key lists those ages. Victim 1, she's age 10. Victim 2, She's age 13, victim 3. She's age 13, victim 4. She's age 13. The vulnerability of these victims, they were alone, or they were with another child, and they were just minding their own business at a resort water park hotel, having fun, a place that's intended for kids to have fun. This isn't a case of kids wandering alone. It's what kids this age do and what we should expect them to do. Have fun when you're at a water park. Judge, I noted here Mr. Paulus, his statements in 5.3 of Dr. Miller's report that go to his motivations in doing this. That's an aggravated factor. And Judge, finally, I'd be remiss if I didn't end with, in terms of this first galleon factor on the seriousness of the offense, not talking about the most aggravated factors, the significant trauma, the emotional trauma on these victims and their families. And I'm just going to highlight a couple of things in the PSI. Victim 2, the psychological impact, how she's in regular counseling, how there are, she is suffering from depression. There have been behavioral changes. It's very difficult for her to be alone. She has a fear of crowds. She needs constant reassurances of safety. This offense occurred on her birthday. That lasting associated here, the lasting association with that trauma on her birthday will be with her forever. She needs proximity to her mother in public settings because of this. Holds her mother's hand in public to ensure safety. A 13-year-old girl. It is a loving act to hold your mother's hand, but everywhere you go in public to have to do that because of this, that shows the effects of that behavior. Now, we hear the mother of victim number 3. I think her comments were appropriate. She described the impact of this offense on her daughter, on her family, on her. Everything she said made sense. This court should place great weight on her comments about the impact of the offense on her daughter and her family. I'm asking you to. Please, Your Honor. Finally, victim number 4. This victim has a vulnerability. She's been diagnosed with autism and cerebral palsy. She has some developmental delays, and she struggles with, understanding, in detail what happened. But naturally, that human feeling is still there within her. And her parents report that she also has behavioral changes. She has persistent anxiety about where Mr. Paulus is. She fears crowds. She avoids situations where she feels she's vulnerable. She has developed a generalized fear. A 13-year-old girl having a generalized fear of life. That pains me to say that, both as a prosecutor and a parent. This child should have hope, because children are the light of this community. Again, it goes to his behavior, what he did. Judge, those were the facts that we offer on that first galleon factor, on the gravity of the offense. Now, here mixed in there are facts, and I guess you could say there are inferences in there about his character, right? But here, as the court here as Wisconsin courts and prosecutors and defense attorneys are guided by the Wisconsin special jury instruction here on sentencing, that we start with the age of the offender and their criminal record. He's 18, again, no prior records. He does have nuisance-like juvenile history, so this is his first, I guess, dive into very bad behavior. And now he's going to have to face a very significant punishment. Going to prison is very challenging, extremely challenging. Here as a prosecutor who handles a lot of cases that arise out of GBCI, that is not a welcoming place. It's a very difficult place here to live. And he is going to experience challenges on a daily basis by being in a state prison. And that's because of his own behavior, no one else's. That's what he deserves, the punishment of going to prison. That's what happens when you have a character trait where you like to do this to get the thrill of it, and you go back and you do it again for the thrill of it. I'm going to let Mr. Kippa speak to the mitigating circumstances with your Mr. Paulus, but look, from our perspective, because of the age and the lack of the priors, that was a significant reason why we are not recommending double-digit prison confinement term.
Thank you.
Judge, lastly, I would say this. We feel that this recommendation protects the public and addresses here the needs of society. And it is our hope, with the 11 and a half years of imprisonment, that he'll be under the government's watchful eye, that he will use that opportunity to avail himself of this state's great resources to correct his behavior. Because if he does not, and if he reoffends again, then and he comes back before the courts, but it will be larger than a sentence of 11 and a half years of imprisonment if the conduct is substantially similar. I will say that. And he will be exposed to the persistent repeater enhancer, and he will be exposed to other habitual offender enhancers. So, Judge, with that being said, this joint recommendation we feel protects the public, punishes Mr. Paulus, provides generalized deterrence, provides individual deterrence, and here offer him your really intensive rehabilitative programming. Thank you.
Then Attorney Kippa.
Thank you, Your Honor. Your Honor, just a bit of housekeeping. He's got 443 days of credit. That does not include today, which I think I'm instructed not to include. Attorney Dorsey, it is a joint recommendation. I didn't want to interrupt him. At one point he said 98 months. It's 8 years of extended supervision, which I think is 96 months. I think it was just, he just misspoke. He's not trying to trick me or anything.
Okay, understood.
Judge, that's correct. Thank you, Mr. Kippa.
Judge, I'll say, and I think it's worth noting, and I'm not trying to undercut our joint recommendation as I say this, but nobody's spoken to the recommendation of the PSI, and I think that's worth putting on this record. While my recommendation is for the 11 and a half years, 3.5 years of initial confinement, 8 years of extended supervision, a probation agent with the Department of Corrections prepared this PSI. I think it's a very well-written and thorough PSI. I can't recall a PSI recently where an agent has spoken to more collateral sources than this agent has in this PSI. She ultimately recommends probation. That's not the recommendation of anybody in this courtroom today, but I think it's worth noting she recommends much lengthier prison sentences imposed in state and then placing them on probation. I just think it's worth rounding out this record as far as their recommendation. So Attorney Dorsey has very thoroughly covered the seriousness of the offense. And in my preparation for today's hearing, I can't say anything, frankly, to diminish the seriousness of the offense here. The impact, as I read through the PSI, listened to the statements here in court, it's heartbreaking. And I would not say anything to try to diminish that or take issue with anything there. So Attorney Dorsey has very thoroughly covered the seriousness of the offense. Regarding the need to protect the public, I think this goes hand in hand with the treatment that's being recommended as part of the pre-sentence investigation. Counseling and treatment for Mauricio, both sex offender counseling and substance abuse, maybe substance abuse greater than sex offender treatment, but both, those will go a long way towards ensuring that Mr. Paulus is never in this position again, and there aren't any victims at his hands. So rehabilitative needs and needs to protect the public go hand in hand. We are suggesting that this court, he's already been off of the streets, so to speak, for a year, 2 months, and about 18 days. So he's already been, the public is, so to speak, protected by him for that period of time. And we're proposing another 2.5 years on top of that, of course, as part of this 11.5-year sentence. So getting treatment, maintaining sobriety, which is expressed in the PSI, the clarity to which he's got, having been in custody, having been sober for 14 months, almost 15 months, and the impacts that they have on him, those will go a long way when coupled with treatment to protect society, to diminish his risk to society. The character of the defendant, Attorney Dorsey has been diplomatic in acknowledging he's 18 at the time of this offense. Some would call him still a kid at the time of this offense. The law doesn't. Certainly the criminal justice system has put him in adult court for at least a couple of years, or going on a couple of years at the point of 18. He's 19 years old right now. I think when addressing his character, this is not by means of an excuse, but I think it would be naive not to address the points made in the PSI regarding substance abuse struggles that his mother has had. And I'm confident that this court, in your capacity as a prosecutor for a number of years, in your capacity as a judge, and this prosecutor who sits next to me, Attorney Dorsey, we all understand the long-term impacts that substance abuse has on an infant, a fetus, an infant, a child, and then even into adulthood, and I'll touch upon that a little bit more. But that's the hand he was dealt, and it directly impacts decision-making and impulsiveness, which is, according to Dr. Miller, which I agree with Attorney Dorsey, is a pretty even-handed evaluation. It ties directly into the challenges that Mauricio has. So it's not an excuse, but it would be naive not to at least acknowledge it. In doing so, and I think I should just touch upon this now so I keep this conversation moving, just a cursory view of impacts of marijuana exposure. I'll just quote from what I've found. A study on marijuana-exposed fetuses found elevated levels of D2 receptor transcript in that front portion of the brain that I can't pronounce of males, suggesting potential for altered emotional regulation. It goes on to say perhaps the most striking is that even in their early 20s, exposed individuals still have deficits in visuospatial working memory and, importantly, impulsivity. And there are sites to those studies. So the impact of the hand he was dealt prior to even being born is still manifesting itself today. And we all should acknowledge what, frankly, we all know anecdotally. The brain is developing until age 25. It's one of the reasons we, have different penalty structures sometimes for younger individuals, albeit still in the adult court system. And so his brain is going to continue to develop over the span. Well, it will be fully developed during the period of the sentence that the parties are proposing today. Regarding that other aspect of galleon and rehabilitation, I think I've touched upon that. Clean and sober, Mauricio is not a threat to the public. This prison sentence that we're recommending today ensures, and Attorney Dorsey touched upon this, the highest level of treatment. Oftentimes this court is probably asked to send people to prison because they've failed so many times in the public or on other periods of probation. Unfortunately, Mauricio, in victimizing these girls, has jumped into the deep end of the pool. And we're not asking that he get a pass, that he get a crack at probation. We're saying these actions require a prison sentence. And as I've heard from other courts, sometimes the system doesn't know what to do, so we're going to give you the highest level of treatment, and that's going to be in the prison system. And that's what we're asking you to do. And as he maintains his sobriety, and as he continues to grow and mature mentally, physiologically, that will ensure safety for the future for the public. And let's be honest here. I mean, there are collateral consequences, as noted by the state, that aren't necessarily part of this sentence. They are, but they aren't. Lifetime registry and lifetime GPS. Those aren't discretionary things that we can ask the court to deviate from with these types of offenses. But they're mandated, and legislatively, they're mandated now. They're components of this sentence that are going to follow him. I mean, lifetime GPS for a 19-year-old man here. That is a direct consequence, a direct reminder of what he did when he was 18 years old. And while it's considered a quote-unquote collateral consequence, it really is a direct consequence and a reminder and a portion of the sentence here today of what he did. I think it's interesting and worth noting the interplay between Department of Corrections PSI and some of the similarities in Dr. Miller's evaluation. And I point out, maybe it's apropos of nothing, I did not provide this evaluation to this PSI writer. So the similarities between the two have come upon themselves independent of one another. The agent, in noting the COMPASS results, notes that there are serious concerns about his use of substances, his ability to control his anger, and likewise his impulsivity. The agent notes, and I quote, mitigating factors include lack of substantial capacity for judgment due to Mr. Paulus's age, not comprehending the true consequences of his actions, and being born addicted to both cocaine and marijuana, and those I alluded to earlier. She further notes it is crucial that the sentence Mr. Paulus receives allow considerable time to address his needs, increase potential for positive socialization, meaningful lifestyle, I assume changes, and make progress in the areas of emotional control, criminal thinking, and impulsiveness. Those correlate to, I think, what Dr. Miller talks about, the basis for his offending, the likely rationale, which is probably the exact opposite word that ought to be applied to these actions, because I don't think they were thought out, but they tie in directly to the analysis that Agent Haney makes in the pre-sentence investigation. A comment was made briefly on restitution. I mean, and I understand there's now a $60 request and that the court will likely hold that open. That's fine. We'll address that at a later date. Today, though, the request has been for nearly $3,000 in restitution. That was prepaid. There is only so much that Mauricio can do to make amends for his actions. And I think in taking care of that restitution payment, that's one of the things that he can do. His words that he'll speak to you in a little bit are one thing. Those actions will play out in years to come. But what can he do as he sits here today to make amends for what he's done? And to the extent that he can do anything, frankly, he's made that payment. And I think it's worth noting. Lastly, Judge, I want to point out Mauricio's family who's sitting here in court today. I've certainly sat very much alone with my client in courtrooms based on horrendous allegations such as these. It's somewhat rare that family remains as close-knit as his family has been, and to attend court appearances and to be here. The agent, as I mentioned, did an amazing job, in my opinion, of following up and having conversations with family members. And those speak better than I can as to their insight as to who Mauricio is outside of drug addiction, outside of the offenses that he's been convicted of and is going to be sentenced here today. So, in that family support, the agent notes this at one point, is very important. It's important to his success because whatever you do regarding a period of initial confinement, there's going to be a component of extended supervision. And him succeeding, frankly, is all of us being better off. We're all safer the more he succeeds. And the fact that he's got a family that sits here behind him and supports him, in spite of the serious charges that he's pled to, speaks volumes, well, to their character, frankly, and I know Mauricio appreciates it, but also to his character and who he presents. I mean, he's young. He was 18 years old at the time of this, but he lived those 18 years with some minor exceptions, crime-free, and a caring, a genuine, generous, empathetic. There are other adjectives that were used to describe him by his family members, and there were similarities and continuity between those comments, which tells me they're genuine comments about who he is. So he knows he's got to be sentenced here, Judge. He's not avoiding responsibility. This case was never really about avoiding responsibility. And I know it's taken some time to come through the system, but these are serious charges. This deal is a product of lengthy negotiations between me and the district attorney's office. In relative speaking, it has come through the system for the severity of these charges in a fairly quick process. These are January offenses, certainly of last year, and we sit here, the plea was probably about a year after the offenses occurred. That's relatively fast. It was not about him not taking responsibility. He's taking responsibility for his actions. He knows you're going to sentence him, and that our recommendation is that you sentence him to prison. So I'll leave it at that, Judge. Thank you, Your Honor.
Thank you. Then, Mr. Paulus, is there anything you wanted to say before I issue the sentence?
Oh, yeah.
If you prepared something in writing, you can just read it, if you choose to do that. Can you pull the microphone closer, Attorney Kippa?
Alright, first I would like to apologize to the victims and the victims' families. I'd like to apologize to the court and my family for my behavior and conduct and misguided judgment in this case. I stand before you as a 19-year-old adult in full cooperation in this case. I humbly ask you to take into consideration the fact that I am so young and how this is going to affect my life for the rest of my life. I'm not asking to go unpunished. I can't undo the mistake I made. Your Honor, I'm asking for a chance to redeem myself and not sit half of my young adult life behind bars. I would like to thank the court for giving me the chance to speak, and thank you for your time and consideration.
Thank you.
Judge, may I just make here, I guess, one change in my restitution comments? So I think I made a reference here, restitution. $2,900 here and $18.89 has been paid here to victim number 4's family. So.
Okay. Thank you. This is a case where Mr. Paulus is convicted of a Class B felony, an attempted Class B felony in count 1, and a Class C felony in count 2. When the court issues a sentence, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, the character of the defendant, and deterrence of others, and apply the Gallian sentencing factors to those sentencing objectives. It is fair to say that there are required punishments in this case. First and foremost, the lifetime sex offender registry requirement with the GPS device. That is a penalty in and of itself that'll have a lifelong impact on Mr. Paulus. And then being convicted of felonies in and of themselves are a penalty as well. You lose constitutional rights just for being convicted of felonies. And then if you reoffend in the future, these convictions can be used to enhance the penalties on future convictions if you commit crimes in the future. The state and and Mr. Paulus are having a joint recommendation here today for 3.5 years of initial confinement plus 8 years of extended supervision. And then it is fair to note that the pre-sentence investigation writer from the Department of Corrections did recommend probation in this case, I think for 6 years on one count, 5 years on the other, with a long imposed and stayed prison sentence. It seemed like a lot of the reason for that was that there are additional penalties for Mr. Paulus as a registered sex offender if he gets a prison sentence, but I think kind of as we're all recognizing here today, those additional requirements that he's going to have are appropriate because of the offense that he committed, and that's why everybody here is recommending a prison sentence. Nobody's recommending a probation sentence. The defendant right now is 19 years old here today. He does have no prior record. He has a high school level education. He does have a regular employment history that's described in the pre-sentence investigation. He took responsibility for the offenses by pleading no contest to 2 pretty serious felony charges. And the pre-sentence investigation writer, after interviewing him, did believe that he was remorseful for the offenses that he committed. He prepaid an amount of restitution to one of the victims. He does appear to have treatment needs for alcohol, THC, and probably mental health as well. And having been exposed to controlled substances as an unborn child. And I do think it's basically common knowledge that the brain is still developing when you are 18 years old. So those are some positive and particular things about Mr. Paulus, but then the court also has to consider the nature of the offense in this case. I don't think there's anybody in the whole world that would look at the facts of this case and not say the behavior was horrendous. I mean, that's just on its face, it's disgusting behavior that the community doesn't have to tolerate. And again, that's why we're all recommending a prison sentence here today, because it is very horrendous behavior that took place in this case, and the nature of the offense is significant, and the negative impact on the victims and their families is enormous. Children are the most vulnerable people in our community. Even a 13-year-old relies on the adults in their lives and adults in the community for their safety, and you participated in violating that important trust that even an 18-year-old adult has to protect children in the community. At the time of the offense, you were 18 years old. The victims in the case were one 10-year-old and 3 13-year-old females. The victims were at a birthday party in one of the incidences, having fun with their family at a water park resort in the community, and the context that this case occurs in is a factor and is an aggravating factor in the court's analysis here today. So you're an 18-year-old going around the facility, groping and basically terrifying children in the community who are present at this facility, and these aren't teenagers who are close in age to you. I think that these would be more like elementary school for the 10-year-old and middle school for the 13-year-old. So even the age difference between you and the victims is not close. I would not call it close. There's no mistaking that this was a victimization conduct on vulnerable individuals in the community. You committed the attempted sexual assault on January 20th, 2024, and then you didn't get caught, so you returned on January 25th, 2024 to do it again to another 13-year-old victim, and I have no doubt that you would have continued to do it if you weren't caught after that January 25th incident. And then even worse than that, this is the type of thing that spreads around the community, and maybe other people would be emboldened to go to places like this and commit the same type of offense because you were able to get away with it. So there is a significant need to deter this type of activity in the community. And while probably not a victim for Chapter 950 purposes, I think the business itself here is a victim on the case. The the impact to their reputation for this business that I think carries itself out as a family-friendly, fun place to take your kids. Stories like this spreading around the community has a negative impact on the reputation of that business. So in that way, I do think that the business itself is a victim of the crime and an aggravating factor as well. There are victim impact statements submitted for each of the 4 victims in the case. Victim 1 submitted a victim impact statement as document 30. With that victim, you pulled down her pants, exposing her underwear to you, making it an attempted first-degree sexual assault of a child. That's why it's an attempt and not a completed act. And then you prevented her from leaving the elevator. She was 10 years old, and you did this to her. In the victim impact statement, she does not express, or it might be a representative of the victim, does not express a specific opinion on the penalty. However, the statement says that her only comfort is knowing that he is in jail. And her parent doesn't know how they are going to tell the victim when you are eventually released, and because she's clearly very scared of you. As to victim 2, she was 13 years old at the time, and you also prevented her from leaving the elevator, so I think that victim goes to count 2 that was dismissed but read in the false imprisonment. In the pre-sentence investigation, a representative of the victim gave a statement. This incident took place during her birthday, so this is the one that has this permanent traumatic scar on her soul forever because of this taking place during her birthday. She's been in counseling for months. Her father recommends a prison sentence, but he does have mercy on you. He says that the sentence doesn't have to destroy the defendant's life. And then her mother wants the maximum penalty because of the repeat behavior that didn't stop until he was caught. So that's the mother of victim 2 actually recommending a maximum sentence. Victim 3 has victim impact statements that were submitted. She was 13 years old. She gave her or a representative gave a victim impact statement as document 37. You grabbed her buttocks twice while she was trying to get away from you. Her mother is the one that testified here today, and what stuck out, one of the things that I highlighted from her testimony, is that she's actually on the other side of the door listening to her daughter trying to get into the room, just to kind of highlight how significantly traumatizing that is for a whole family at that point. She's recommending 4 years confinement for each of the 3 victims of the sexual assaults. In the pre-sentence investigation, she gave a statement stating that there's ongoing counseling. She's afraid to be around men. She has fear of being alone. It's impacting her at school. And then in the PSI, the mom gives another recommendation of 6 years initial confinement plus 10 years of extended supervision. And then a lot of the things that she testified about here today and gave a statement on are consistent with those prior statements that highlighting that there's still a struggle mentally, emotionally, and physically in this family. Her words were that you messed up our daughter over something that you found funny. Her sibling was present and felt helpless to be able to stop what was going on. She's afraid to use public restrooms. And one thing that really the court was paying attention to was when the mother said, you had time to think about what you had done, and you still decided to return about 5-6 days later and do it again, which was your conscious choice in this case. And then as to victim 4, she was 13 years old at the time. There's a statement in the pre-sentence investigation from victim 4. You snuck up behind her and pinched her buttocks. She seems to be a person that seems to be a special needs child, making it difficult for her to cope with the victimization, even with counseling. She frequently inquires about the defendant still being in jail, and she is now afraid of being in crowds of people. When you victimize someone in the community, you have to accept that victim as who they are. And this victim being of special needs, being a special needs child, I think is an aggravating factor that the court is going to consider here today. The mother in this case, for this victim, recommended 6 to 8 years prison. So the bottom line from hearing from all 4 of these victims or their representatives is that you changed the course of these child's lives. I mean, this is exactly the type of offense that could stay with somebody forever. They could ideally get treatment, maybe get past this for a year or 2, grow up to go to college, get a job, and then 30 years from now, some experience will happen to them in life that'll re-traumatize them, and they'll think about what happened to them when they were 10 and 13 years old. This is the type of offense that can re-traumatize somebody for the rest of their lives. So the impact in this case, the court certainly is considering as being potentially lifelong trauma for the victims in this case. The Victim Rights Amendment to the Constitution is Article 1, Section 9M, and the purpose of that amendment is to empower victims. It gives them a voice in the process, and Section I specifically gives them the right to be heard, specifically at sentencing. So that's what was presented here today when we first started. Normally I do give a lot of weight to joint recommendations. The lawyers are in a better place than the court to evaluate and understand a case. The lawyers get all of the police reports on the case, they're able to investigate, actually talk to witnesses and victims on the case, and the court is not. So that normally the lawyers are in the best place to evaluate and understand a case. But I think that this is a case where the victims and their families are in a much better place than even the lawyers in the room to understand this case. So when I analyze all of the sentencing objectives, I do think that all of the sentencing objectives do point to a much higher sentence than what is the joint recommendation here today. There is a need to protect the public from this type of activity. I've gone over the significant nature of the offense significantly at this point, and the need to deter individuals going to a family-friendly water park resort and groping 10-year-olds and 13-year-olds at a birthday party is significant, and the community needs to know that there's a significant penalty for that to deter other people from doing that. So deterrence is a very significant sentencing objective here today also. So when I consider all of those factors, the total sentence here today is going to be 10 years of initial confinement plus 10 years of extended supervision. That is going to be on each count concurrent. I think the maximum penalty does allow that. And then you do have to register as a sex offender for the rest of your life. $60 restitution to victim 3. I am going to give 1 year to submit any additional restitution. I think this is a case where there could be additional costs over a longer period of time if the victims choose to seek restitution. Compass evaluation, AODA assessment, follow through with all treatment recommendations, maintain absolute sobriety, no contact with victim 1, victim 2, victim 3, victim 4, or their families, no contact with anyone under the age of 18 unless prior approval is given by the Department of Corrections, comply with chaperone agreements and recommendations of the Department of Corrections. That does not apply to any biological children you may have. No contact with Tundra Lodge, participate in sex offender treatment, evaluations, and follow all treatment recommendations, participate in all assessments, evaluations, and treatment recommendations deemed appropriate by the Department of Corrections. You do have to pay the court costs, and then you do have to apply a DNA sample as well and pay the surcharge. There's 443 days credit on the sentence. Did the state agree with that?
Judge, no objection.
And then Attorney Kippa, anything to clarify?
No.
From the defense, or from the state, anything to clarify?
No, Your Honor, I will just want to supplement the record, and I don't know if I mentioned this, but part of the basis was in the joint recommendation, I think it's important, was to avoid having to put these girls through a trial as well. And that was an important factor that went into the analysis, wanting to avoid re-victimization and further causing here additional harm. So I think that's important here to note. That is a factor in this recommendation that was made. Thank you.
Yeah, the court did consider it by saying that he took responsibility for the offenses by pleading no contest. You do have the right to seek post-conviction relief, including assistance to the public defender's office if you qualify. Otherwise, that is the sentence of the court.